Okay, continuing with reporter's privilege, I am now on slide 8, shield laws. Reporters also often have testimonial privileges created by state shield laws. That's when a state creates these, it's called a shield law, not journalist privilege. 1893 was the first shield law, and in 1972, there were about 12 states that had a shield law. By 2003, 30 states and the District of Columbia had them, and today 49 states have shield laws. Wyoming is the state that does not yet have a shield law. Your privilege varies in general in civil versus criminal cases, in grand jury hearings versus trials, eyewitness versus secondhand information. Are you a party to the case? Uh, for instance, in Brandsburg, were you actually making marijuana cigarettes? Were you actually rolling the marijuana up and doing it yourself? State versus federal court. Which state are you in? And did you promise confidentiality? Can you reveal confidential source if you want to? In Cohen v. Cowles Media Company, 1992, here are the facts. Dan Cohen, an ad exec and a person active in politics, just before a 1982 election, offered 4 local news reporters information about a prior misdemeanor shoplifting conviction of a Democratic candidate for lieutenant governor. Reporters from Minnesota Star Tribune and the St. Paul's something something agreed to keep his name confidential. Issues. Is a reporter's confidentiality agreement with a source a legally binding contract? This is what I was talking about before. If you make a contract, does the First Amendment give the reporter the right to break that contract without being punished? So is it legally binding? Yes. The second question, does the First Amendment give the reporter the right to break that contract without being punished? No. So you get into double trouble. You get into trouble with the law, and you get into trouble with the person whose identity you promised to keep confidential. Slide 11. Here's the rule. The First Amendment Free Press Clause does not mean the media can break contracts with impunity. Journalists have to follow the same laws as other people. Enforcing contracts has only incidental effects on news gathering and reporting. Cohen won $200,000. Now, we're talking 30 years ago. What would that $200,000 look like today? $500,000? $600,000? $1,000,000? I don't know. I don't know. All I know is I don't have that amount in my bank account, and you probably don't either. Now, going to Zurcher v. Stanford Daily, here are the facts. Stanford University student paper covered a student demonstration at a hospital that resulted in violence and injuries to police. The paper published articles and photos. The police got a search warrant, convinced the judge that there was reason to believe photos and negatives would help them ID people who had assaulted the police. Issue: does the First Amendment protect the media from otherwise legal newsroom searches? No. If you are in possession of information relevant to a crime, the police can get a search warrant to go in and seize that information on the basis of Stewart's 3-step plan. Zurcher v. Stanford Daily continued. The Supreme Court decision closely parallels its decision in Brandsburg. Journalists do not get more First Amendment protection than other citizens. The Fourth Amendment protection against unreasonable searches and seizures that everyone enjoys is adequate for journalists too. Police need to be allowed to do their jobs. Legislatures can create a privilege by statute if they desire. But with this three-step plan, why would they do that? They already have a way to get the information now if a crime is involved, and that's what they're concerned about. So, Privacy Protection Act of 1980, passed by Congress in response to Zurcher. It parallels the state shield laws, and I thought I had more about the Alabama state shield law, which I'd like to show you. Hang on, let's stop here and I'll find it.